Okay, Shannon, you can put us on the record now.
Okay.
Okay, this is the matter of Stepp versus Ellis. Mr. Rosenthal for the plaintiff. Ms. Stepp is present, as is Mr. Ellis. And Mr. Rosenthal, this is your motion?
It is, Your Honor. Thank you very much. Your Honor, and it's pretty much set forth in the motion itself. Just to point out, the judgment was entered on November 24th of 2014. It was then clarified, I believe, on May 19th of 2016, basically confirming that Mr. Ellis was awarded a 2005 Cadillac and was to be solely responsible for any and all debt on that vehicle. It's my client's understanding that that vehicle may have actually been repossessed and or taken away due to non-payment. She recently, I believe in November, started getting letters advising her, and I think it was attached to the motion as well, indicating that there was an issue, that there was a balance due, that she received that letter from, I believe the company was called Risk Management Acquisition. Risk Management actually purchased the debt from DNF Associates, who purchased the debt from Flagship Credit Acceptance, who was the original loan holder on the actual vehicle itself. And that's why Ms. Stepp is pretty convinced this is the actual vehicle for that, the loan for that vehicle, because she does not have any outstanding loans. She's received that letter. She's receiving phone calls now. The judgment is very clear, Your Honor. He's responsible for that debt. He's responsible for that asset. If he lost it, that's on him. Whatever happened to it, that's on him. Fact of the matter is, it's now technically going to be affecting her credit as a result of the letters she's getting, the phone calls she's getting, so forth and so on. There may be a time lag. I do understand that sometimes when debtors purchase these bad debts, there is a time lag. But as far as she knows, there's never been any verification that this debt has in fact been satisfied. And that's what we're asking for, at least either proof or that he satisfied this debt, because he is in contempt of court, basically for not following the terms of a provision in a judgment and the amended judgment for purposes of taking care of that responsibility. So we would ask the court hold him in contempt if he can't prove he took care of it. And if he hasn't taken care of it, to take care of it within 30 days. Otherwise, it's going to continue to adversely affect my client. Your Honor, also, this matter was scheduled. There's a custody matter and a parenting time matter that was also attached to this, that in the motion, I had requested that the matter be removed from the front of the court to the court. When attorneys are involved, I know the front of the court doesn't really like handling these types of matters. I believe it would probably be more time effective for purposes of removing it to the court rather than before the front of the court. In doing so, I would also ask, knowing the issues that are actually being presented, perhaps the court appoint a guardian ad litem that the parties would equally divide the cost for. I would recommend perhaps Rebecca McCluskey, who I know does some of these things, for purposes of getting to the actual issues. There's a lot of what I will call he said, she said, that, you know, Mr. Ellis is making these claims. My client can verify they're not true. There's a lot of school-related issues and stuff like that I believe that a guardian ad litem would actually serve very well in a situation like this, to really understand what's going on, to get to the bottom of it, to look at the school records, to do all the things that perhaps the court may not have the time to do or be able to do, to understand these specific issues that are going on, to make a recommendation to the court. So I would ask that the court, one, hold Mr. Ellis in contempt, two, require him to satisfy that obligation within 30 days if he has not done so, three, set this matter before the court, and four, appoint a guardian ad litem, including perhaps Rebecca McCluskey, who I know is well-versed in handling these kind of matters for purposes of trying to look into these underlying issues.
So, Mr. Ellis, let's take these one at a time.
Sure.
What can you say about the debt on the vehicle?
Well, as far as the debt on the vehicle, they had called me. Me and Brandy had spoke with it. They had called me, and I tried to work out payment plans with them. If they don't want to accept what I can offer, I cannot help that. I never once said that Brandy should be stuck with the debt. I agree. She got the Impala. I got the Cadillac. No one's sitting here trying to stick her with the debt. I assume responsibility for that, and I'll take care of it. But it's a little hard to fulfill a $500-month obligation when I'm paying close to $2,000 a month in child support. I just paid double payments for the last 3 months. But other than that, and I'm on unemployment. So, but yeah, I'll get a hold of them, try to work something out. But other than that, that's all I can say on that.
With respect to removal of the hearing from the referendum.
I'm sorry, what's that?
With regard to the request for removal of the custody hearing from the referee to the court. I usually grant that when there's an attorney involved.
Sure.
So I will grant that. So instead of the referee hearing it, I will hear it. Dawn will find a date for you.
Okay.
Regarding appointment of an LGAL,
Yes, sir.
we used to be
Sir.
let me speak to that.
Sure.
I like when there is an LGAL. It does give me greater insight as to particularly where the children are coming in all of this.
Sure.
The LGAL is able to gather a little more detail than I can. When I do an in-chambers interview with a child, it's very, very limited simply to what their preference is.
Sure.
The LGAL is able to gather more information, and it's helpful. But
Sure.
on the other hand, I recognize that this comes at an expense. If parties can't afford an LGAL, I don't like to burden them. We're already having trouble taking care of a debt that you acknowledge is your responsibility. So
Yes, sir.
much as I would like to order an LGAL and the expenses shared, it doesn't appear that Mr. Ellis has the ability to pay for half of a LGAL.
How much is it, sir?
Mike, have you seen a bill from an LGAL in recent time?
Your Honor, just to let you know, I actually reach out to like Rebecca and other LGALs for purposes of trying to find out what their fee schedules are to see if they'd even be interested in doing it. In speaking with Ms. McCluskey, I think she said she's looking at like, I think she technically would bill per hour, but I asked her, some of them actually put down an amount. She indicated it was like $600 to $800 that she would actually require that would be split between the parties for
Yes,
purposes
sir, I
of
can-
getting involved.
I have no problem covering that. I'll pay half that, Your Honor, if it'll help.
All right. It is very helpful to me.
Sure. But listen, can we pick? I don't want to go with the LGL that he's picking. That's not fair to me. I want to go with one that you pick. I don't think he should get to pick it at all.
The one that he's identified is frequently serves as an LGAL in my courtroom.
Okay.
She actually is appointed counsel in my neglect and abuse docket. She's very fair, Mr. Ellis. You don't have to have any concerns about her having some kind of a special relationship with Mr. Rosenthal.
Okay.
She would be a good one.
Okay, sounds good. Yeah, that works
Right,
for me.
so-
I'll cover half of it.
So I will order that. So Mr. Rosenthal, then back to the remaining issue with respect to the vehicle debt. I know it's in the judgment of divorce. I know it ordered Mr. Ellis to take care of that, but this is a monetary provision. It's not spousal support. It's not child support. I don't have the ability to enforce this with my contempt power. What I can do is authorize to any extent that Ms. Stepp is held financially responsible, she will be entitled to a money judgment against Mr. Ellis to reimburse her for any expense she incurs. I can't do anything about the impact to her credit, but this is like any other money judgment. That's what it is. I don't enforce that with my contempt power. I enforce it with debt collection remedies, and those are available to you. Clearly, Mr. Ellis acknowledges it's his obligation. He doesn't have the ability to write the check today for however much it is to take care of this whole debt. But if Ms. Stepp is responsible, they garnish her, they do anything to try to get this from her, Mr. Ellis is required to indemnify her for that. And I will certainly recognize any kind of post-judgment monetary enforcement that you see appropriate under the circumstances.
Okay, thank you very much, Your Honor. I'll be
Mr.
happy to
Rosen-
prepare an order too. So
Thank you very much. And
Your
we'll
Honor.
try to find you. Yes, Mr. Ellis.
You said today we could discuss, in your original order, she's supposed to provide transportation halfway when I get Kenneth, and she has never one time done that. I live 2.5 hours away. So therefore, I flipped the bill for gas all the way there, all the way back. That's 2 trips in a weekend. We're talking over. I want to be compensated for all the times. And from here on out, I want her to meet me halfway. And she says, oh, it's too far away, this and that. Well, according to the thing, she's supposed to meet me halfway up to 200 miles or something. But she has never one time done it. Never one time. Never.
I don't have that in front of me this morning.
Your Honor, if I may,
what's
it's my
the-
understanding that's the issue for the evidentiary hearing. I don't necessarily know the court ever ruled on anything. He's the one that moved. He's the one that actually made this an issue. I don't know if she has any obligation to actually meet halfway based upon the fact he's the one that moved away. But it's my understanding that was something the court indicated they would address at an evidentiary hearing.
Sir, I just moved here a year and a half ago. He signed an order in 2016. That's 5 years ago. So there's 3.5 years that she didn't meet me halfway. And why would I not be willing to meet her halfway if I drive the whole way there and back 4 times in a weekend? Does that make any sense?
Your Honor, can I speak?
Sure.
The order that you had signed was very specific. It says that we are to meet in Jackson on Northwest Avenue at the Shell gas station. That was the last order. And since then, he doesn't live in Jackson anymore. There's never been another revised order.
Right. And Your Honor, that's part of the judgment of divorce. If the court wants to look at it, it's page 3 under parenting time. It's the last paragraph that says they meet in Jackson.
I will address that at the evidentiary hearing. If that needs to be remedied, I will certainly listen to arguments and make any order necessary at that time to rectify this situation.
Thank you very much, Your Honor.
You can include that in your order, Mr. Rosenthal, just to make sure it doesn't slip my mind.
Sure. I think it was on the notice for the last one. It indicated custody, parenting time, and transportation.
If it's already there, then we'll address it then. Thank you.
Thank you very much, Ron.
Well, I don't see anyone present on the Carnell matter. Looking for first names. So I'm not sure what happened with that. Let's see. Let's get Mr. Roby taken care of if we can. I don't see Mr. Kelly present. Oh, there he is. Okay, since Mr. Roby is lodged, I thought it'd be good to get his case called. This is Adams versus Roby. Trying to figure out who else should be present.
Your Honor, I think my client Allison should be, but I don't.
She is. I just found her. She's joining us.
Okay. I think that's it. It would be just us 3.
I saw mention of a third-party intervenor. Do you know anything about that?
unless that was in reference to that, the case that's going on down in Hillsdale, I'm not sure who that would be.
Let me see if I see that attorney. Yes, here he is, Mr. Kershaw. And let's see, we've got Cameron Bifus. Once we have an audio connection, we'll move forward with this one.
Good morning, Your Honor.
Okay, well, good morning.
On behalf of Cameron Bifus. I don't know if Mr. Bifus was planning on being here as well. I thought he was, so I don't know if he's in the waiting room as well.
We were just waiting for his audio connection to be completed. He is present.
Yeah, I'm here, Your Honor.
All right, and we're having trouble with Ms. Adams' audio connection, so we need to wait on that.
Judge, who's Cameron B?
Bifus, third-party intervenor, Beilfuss.
Called him twice. I know. Oh my God. He didn't seem sick when he was in here.
Do any of you happen to have Ms. Adams' telephone number? I could try to connect with her by phone. We're having trouble making an audio connection with her device.
I do, Your Honor. Allison, if you can hear us, just.
Oh, okay. Looks like we've got her finally.
Okay.
Ms. Adams, can you hear me?
Yes, I can hear you, Your Honor.
Okay, very good. I was a little confused. The caption I was looking at, Mr. Kelly said that you represented Mr. Roby. So, all right. This is on, it says on the docket that it's here on a motion for consolidation. I didn't see a motion for consolidation in the file. All I saw was a motion for intervention and to dismiss filed by Mr. Kershaw on behalf of Cameron Bifus.
Your Honor, I don't have those pleadings, so I'm not sure what was filed by Mr. Kershaw, but I have not been given a copy of those pleadings. But the motion for consolidation should be in the file. It's one of the court form files from SCAO. It would only be one sheet of paper. If Mr. Kershaw has filed a motion, I should be entitled to a copy of it, and I would request to adjourn it a week so I can actually see it and respond to it.
And I will say that my office both emailed and snail mailed a copy of that motion to Mr. Kelly on April 7th. If the email that I have is mjkelly10@ameritech.net, which I believe my secretary got off of the State Bar website. But by the same token, if Mr. Kelly has not received it or has not had a chance to review it, I have no objection to adjourning it to give him an opportunity to be prepared to address it. I mean, I just wanted to make it clear for the record that my records indicate that we did serve Mr. Kelly both by mail and email.
Have you been able to locate it, Mike?
No, I looked in my spam folder as well as my previous history in the file that I have, and I don't have it. And I haven't gotten through the mail either, but that's that in and of itself is a mess, as we know.
Yeah, well, that's part of the reason I wanted to make sure she emailed it to you as well, is because I know that the way mail's been lately, getting something from Monroe to Jackson in 8 days.
Is there a better email address, Mike?
No, that's the correct one. Maybe Mr. Kershaw can try that again. And
I'll try shooting it from my own personal email. I think it would have come from my secretary's email, but let me.
It would certainly appear that the motions are related. If the only reason I would like to avoid postponing it is we have Mr. Roby here, and it's a burden on the department to have somebody here and just have him brought back in a week. Do you have time? I don't want to force the issue, but do you have time this morning to take a look at it, Mike?
Depending on how big it is, yeah, I think I would. More importantly, do you have my motion for consolidation? Have you looked at that in the court file?
I do have it, yes.
Okay. I think in some respects that's going to require a measure of communication between you and the judge down in Hillsdale as well. Has the court been able to do that?
I haven't made any attempt to do anything. This file was just brought up to me with my hearings that were scheduled for today. So I haven't done a thing with it. It was noticed for hearing. So here we are.
Okay.
And I would agree with Mr. Kelly's assessment that if the court were even inclined to consider the motion for consolidation, I think it would involve it would involve some input from Judge Lisney down in Hillsdale County. My position, and I'm not going to argue it too much because I know Mr. Kelly hasn't had a chance to read the motion yet, but just in brief, my position is going to be that this is better handled in Hillsdale County where it's been for quite some time. I just sent via email a copy of the motion. And exclusive of exhibits, it is 3 pages. And I believe the exhibits are all things that Mr. Kelly should already be familiar with.
I don't know how busy either of your mornings are. What I could do is put you, Mr. Kelly, in a breakout room with your client so that you can talk about this. And if you still wish an adjournment, I will give you an adjournment. I'm just hoping if I can resolve it this morning without everyone having to come back, I'm happy to do that. I don't want to force the issue. But if you got time this morning, I wanted to at least give you that opportunity.
Okay.
And just for the record, Judge, I'm free until 10 a.m. So, if Mr. Kelly is if we're able to do this before 10 a.m., that's fine with me. I just need to let the court know that I have another commitment at 10.
I will call another case and then I'll come back to you.
Okay.
Let me create a couple breakout rooms so that you at least have a chance to visit with your client while you're waiting.
And I don't see him. Is Mr. Bife is still on this call?
Yeah, I'm still here, Joel.
Oh, okay. I wasn't seeing you. Mike, did you receive the email I just sent you?
Yep, I got it.
Okay.
Okay, so just follow the instructions for getting into the breakout room. Mr. Roby, I'm going to put you back in the waiting room. Sorry. I'm hoping to get this resolved today so that we don't have to trouble you a week from now or whenever it is we can get it rescheduled.
Well, I got nothing but time, so it'll be okay either way.
Okay. All right, where are we? Carnell. That's the one where I didn't see Mr. Navarre. Oh, here he is. Ms. Adams, you should see a selection that allows you to go into a breakout room. Did something appear on your screen?
No.
Well, that's not going to work then. What I can do, you're doing this with your phone or with a different device?
I'm doing this with my phone.
What you could try doing is hanging up, call Mr. Kelly so that you can have a conversation with him. I don't know why it's not working. It usually works for everyone else. Somewhere on your screen, there should be a button appearing that you hit that puts you into a breakout room.
Yeah, I'm not seeing it, Your Honor.
And I've never connected with a phone, so I don't know how it appears. So you might just try doing that. I'm going to put you back in the waiting room, and what you can do is just call Mr. Kelly. That way you can communicate with him while you're waiting.
Okay.
Mr. Navarre, good morning.
Good morning, Your Honor.
So this is Campbell or Hines versus Carnell. I'm looking to see if there's any other parties present. I'll double check. I didn't see any. Well, I've got one phone number. Oh, wait a minute. I've got a Keegan. Let me bring him in.
That'd be my client, Your Honor.
All right. And I see Randy Campbell now, so I'll bring her in as well.
Thank you, Your Honor.
As soon as we have an audio connection with everyone, we'll move forward.
Thank you, Your Honor.
Ms. Campbell, can you hear me?
Yeah, I can.
Okay, this is a matter of Campbell versus Carnell. And it is the defendant's motion by his attorney, Mr. Navarre, for a specific parenting time. Go ahead, Mr. Navarre.
Thank you, Your Honor. I know Your Honor's had an opportunity to review our motion. My client is entitled to an order for specific parenting time, and plaintiffs have refused to allow my client to have parenting time with the minor children on numerous occasions. And recently she has allowed him to have time with the kids, but it's been very sporadic over the last couple of years, and he seeks to have parenting time in a frequency, duration, and type that's reasonably calculated to promote reunification and to promote the best interests of the kids. He's had, he seeks at least telephone communication as well in a duration and type that's reasonably calculated to help reestablish the bond that he seeks to have with the kids. The parties live in very close proximity, actually within walking distance of each other. You know, he exercised alternate weekend parenting time in the past, Judge, but it's been almost 3 years since she's kind of cut off ties with him having physical parenting time, and certainly we would like to have, my client's willing to participate in whatever kind of counseling the court may order, but clearly he's entitled to parenting time. Certainly he's entitled to what we define as reasonable rights of parenting time in the front of the court handbook. And so we're seeking that with an order from the court today.
So, Ms. Campbell, absent agreement of the parties on a specific parenting time schedule, what the court has to do is schedule the matter for an evidentiary hearing, take testimony, decide what's in the best interest of the minor children. Are you willing to agree to some specific parenting time schedule?
Yeah, I am. The kids just have a lot going on. So, but yeah, I want the kids to see their father, and both of the kids want to.
Well, typically what I view as the minimum necessary to foster that strong relationship with the non-custodial parent is what is described in the front of the court handbook as reasonable rights of parenting time. It involves the most prominent feature is every other weekend parenting time. It also allows for a midweek visit. There's provisions for breaks and summer vacations, etc. Is that something that would be acceptable to you?
No.
And what about it is not acceptable?
The simple fact that he has not been present in almost 3 years, and he did that on his own. And our son is autistic, and he requires a lot. And with him not being in his life, and it's different for each child, I think. I'm sure Eden, our daughter, would be perfectly okay with it. And I talked to Isaac about it, and he said that he would only want 5 hours with him. I think supervised visits would be the best to start.
Supervised because you're worried that Mr. Carnell would be a danger, or because of the specific needs of this child?
I worry for my son, and because I don't think Keegan will be able to handle him with all the things that he does and the way that he acts, and with things that have happened in the past. I just don't think he'll be able to handle it.
So let me explore just a little. I understand that with autistic children, that upsetting their routine they just don't handle it well. They just don't handle it well.
No.
And if you can get them on a regular routine and keep them on that regular routine with consistency in how that's handled, they just do a whole lot better. I mean, am I describing this accurately, ma'am?
Yes.
So, I mean, one possibility, and you're absolutely right. When the court is tailoring parenting time, I have to look at each child individually. If they're normal, healthy children, typically we treat them the same. But if one child has unique or special needs, we have to make arrangements for that. So if reasonable rights of parenting time works for your daughter but doesn't work for your son, we could at least implement that, and then maybe figure out a good way to transition. And I'm sorry, I lost your son's name. What is it?
It's Isaac, Your Honor.
Isaac. We would absolutely look at something gradual for Isaac. I see Mr. Carnell nodding his head. It looks to me like he agrees that, yeah, we need to go slowly with Isaac to make sure that he can handle it.
Yes.
So one possibility, and again, I can only do this today if you can agree on something. If you can't agree, then really the only way I can do it is by having a hearing where I hear what evidence that each of you present and then make a decision of what's in the best interest of the child. But based on what I've heard so far, that's very much what I'd be inclined to do, is to come up with some kind of graduated schedule. And often I don't like the arbitrary schedules. I know a lot of judges like to do that. Okay, here's stage 1, here's stage 2. I don't like them because they're arbitrary. What I like to do typically is order, okay, here's what we're going to do for the next 6 weeks or 2 months. And then we're going to bring you back in and I'm going to talk to you some more and we'll figure out what does the next phase look like. I don't like going to the next phase if the kid's not ready for it. One thing we can do, and I'll throw this out as a possibility, is we could start the reasonable rights of parenting time as to your daughter. As to Isaac, parenting time as the parties can agree. And if at any point you reach disagreement, you can automatically come back in front of me without filing a new motion, just simply request for a hearing. And I can try to see if I can broker something that works, or if not, schedule a hearing and deal with it. So let me ask you, Ms. Campbell, how does that approach sound to you?
I have a question.
Go ahead.
After almost 3 years of being absent, he's just going to be able to take and have Eden stay the night and do whatever he wants. And what if she wants to come home? What if she doesn't feel safe staying there?
All right, well, let's back up. I was making an assumption based on something you said. So I get that, moving from hardly any visits to staying overnight. How old is she?
She will be 7 in June.
Okay. When's the last time she actually spent an overnight with her father?
July 6th, 2018.
This would normally call for something gradual before we move directly to reasonable rights of parenting time. If I had a hearing and heard all the testimony and this is how the evidence shook out, yes, I would be looking at a graduated schedule. We wouldn't go straight to 2 overnights in a row. We would do an overnight and see how she handles it. If as time progresses, she gets more and more comfortable spending time away from mom and spending time with dad, we can build it. That's typically what I would try to do. From Mr. Carnell's standpoint, I know he's going to want something where he's got some input into what's happening. He doesn't want it to be you're just dictating everything. But the best way to do this is with the two of you communicating and working towards the goal. So here would be the goal, that we get both kids to where they want to go, they're comfortable, and they're spending this reasonable rights of parenting time every other weekend thing with dad. But it's not going to happen quickly. It'll happen more quickly with your daughter than with Isaac. It's going to take a while for that to happen. One possibility, and I'll just throw this out, I don't know, Mr. Navarre, what your time availability is this morning, is I could put the three of you in a breakout room, let you talk, see if you can figure out something and come up with an order today that works. And if not, I can always set a hearing. I mean, that ultimately, that's going to fall on me if you can't work it out. But it's always better if you can work it out, where the two of you are working together. Do you have time to do that this morning, Mr. Navarre?
I only have one other matter before Your Honor today, and it's the Miller matter. But I certainly would like the opportunity to do that. And if you could put us in a breakout room now, I'd be happy to talk with Ms. Campbell and my client to see if we can agree on something temporary, and then maybe just come back for a status, in 4 to 6 weeks.
All right, let's try that. Let me handle the Miller matter so that you don't have something else holding you up.
Yes, Your Honor.
So, Ms. Campbell and Mr. Carnell, I'm going to put you both back in the waiting room for now. And as soon as we finish the other matter with Mr. Navarre, I will create a special breakout room and put the three of you in it. Okay?
Sounds good.
Okay.
You'll get some instructions on your screen. Just follow those.
Yes, Your Honor.
Okay.
Okay, so let me find that other file. Okay. On Miller versus Miller, let me see if I've got, there's Benjamin Miller. Let me bring him in. I don't see oh yeah, here we go. Here's Michelle Miller. Okay, let me make sure I've got a connection. Mr. Miller, you can hear me okay?
Yes, sir, I can.
And Ms. Miller, you can hear me?
Yes, I can hear you.
Okay, this is a matter of Miller versus Miller. When we're here, I believe, on Mr. Miller's objections to recommended order from referee Manzer. Mr. Navarre, I'm assuming you received a copy of the objection?
Yeah, I did, Your Honor, and I think the matter should be set for a brief hearing before Your Honor. On the objections, there's some issues that do need to be addressed, and I do believe that referee Manzer did not address the issues that were pending before him, and I believe that Mr. Miller's objections are appropriate. So I think the matter needs to be set for just maybe an hour or two to be heard before Your Honor, so that you can take testimony and review exhibits and make a factual finding.
All right, so that makes sense to me. I'll have Dawn find a date and time that we can get you all back in here. I can hear whatever evidence either party has and be able to rule on Mr. Miller's objections.
Thank you, Your Honor.
I will have her get a hold of you and let each of you know what date that's going to be.
Your Honor, I don't know that it's necessary that an order enter. We can just receive notice and then have the matter set for evidentiary hearing, or would you like me to prepare an order and submit it?
I'll just have Dawn schedule a date and send out a notice of hearing.
Thank you, Your Honor. Thank you, Mr. Miller. Thank you,
Thank
Michelle.
you.
I will be in touch with you, Michelle. And Judge, if you could put me in the breakout room, I would be grateful.
Okay, it'll take me just a moment because I created a couple breakout rooms, and sometimes it's challenging to create a third one. So Mr. and Ms. Miller, we're done
Yes.
with your case for today, so you're both free to leave.
Thank you, sir.
Thank you.
You're welcome. That's what I was afraid, Phil. I don't think it lets me create. Well, wait a minute. I've got a room that's not being used. Let me Let me put you all in that room.
Thanks, Judge.
So, Mr. Kelly, I see you're back. Let me, I'm going to close these rooms. That'll bring Mr. Kershaw and his client back in. And I think I'm going to have to let yours back in. She couldn't figure out how to get into the breakout room.
She told me that she was going to call back, Your Honor, just using the audio because her video is lagging so much.
Okay. Well, let me do this. I want to create a new breakout room, and I got to close the old ones to do that. And let me see if I can find her. I've got a 269 number. That's probably her.
Yeah.
So we have Mr. Kershaw and his client back, and I think Ms. Adams, is that you at the 269 number?
Yes, it is, Your Honor.
All right, so sit tight for just a second, please, while I create a new breakout room for somebody else.
Okay.
Oh, here we go. Sorry, I was having trouble finding Ms. Campbell. Okay, Mr. Navarre, I'm creating that breakout room for the three of you now. Okay, so we are back on in the matter of Adams versus Roby and third-party intervener Cameron Bifus. Mr. Kelly, are you able to proceed today, or do you still wish for the court to adjourn the matter?
Your Honor, after reviewing the motion, I feel compelled I need to file a response to it. So I think what makes most sense at this point in time is for you to simply adjourn it 1 week. Mr. Roby's even received his copy of it, but more importantly, I'd like to get a response in. And I think that also just as significantly gives this court an opportunity to contact the judge in Hillsdale County so that you guys are on the same page. So when we reconvene next Thursday, if you two have spoken and determined ultimately what's the best course to take, that would probably make the most sense.
I would not be available next Thursday in the morning at the same time.
Any reason we couldn't put it over 2 weeks then? Is there some urgency here?
I know we could probably. I mean,
I know Mr. Kelly has a motion pending, I believe, in Hillsdale County on the same matter on May 3rd. I don't know if we want to resolve this before or after that motion on May 3rd in Hillsdale County is resolved.
the 22nd, what time is Mr. Kershaw available? Which is next week.
I would probably say I could probably be available by about 10:30. It really depends on the other courtroom.
But why don't we set it for 11 a.m. then, a week from today?
That works.
Okay, that's what we will do. Just renotice your motion. For that date and time, and we'll make arrangements, Mr. Roby, to make sure that you're present a week from now. Mr. Roby, did you have any questions for the court?
I was under the impression that I might be getting a court appointed. Was that this court or is that Hillsdale Court, or does anybody have an idea?
We don't appoint attorneys in this type in a custody matter, so I don't know
Okay.
if you've got some other kind of matter pending, but we don't have any funds available for attorneys in custody matters.
Your Honor, this is
Maybe
actually
I
a paternity
misunderstood.
complaint.
I'll say that again, Mike.
Your Honor, the case before yourself is actually a paternity complaint, so he'd be entitled to court-appointed counsel.
Oh, okay.
But
we will.
It may end up in Hillsdale where he'll still get court-appointed counsel. So.
All right. So, Mr. Roby, we will definitely address that, but we're going to figure out which courtroom this case is going to be in before we do it. If I appoint, it'll be somebody that's here in Jackson County. If Hillsdale ends up retaining or having both cases, then the Hillsdale court will appoint someone.
Okay.
All right. We'll see you all back here at 11 next week.
Thank you, Judge.
Thank you, Your Honor.
Have a good day.
Thank you. Okay. Cardell is talking. Hold on to that. Goebel. I thought Goebel went away. I think it did. Let's see. It's like Stinson went away too. So that brings us to Terry. Okay, looks like we're ready for Terry versus Terry. As soon as we have an audio connection with both parties, we will proceed. Ms. Terry, you can hear me okay?
Yes, Your Honor.
And Mr. Phillips, good morning.
Good morning, Judge.
So we're just waiting on Mr. Terry's. There we go. Mr. Terry, you can hear me?
Yes, sir.
Okay, and Mr. Phillips, this is your motion to get paid.
It is.
Who is Ryan here for, Your
Uh,
Honor?
he's here on his own behalf as a mediator.
Okay.
Go ahead, Mr. Phillips.
Thank you, Judge. Prior to being a mediator, I was appointed this court as the lawyer guardian ad litem for the party's children. And I've served in that regard for many months prior to being requested by the parties to serve as mediator regarding certain disputes they've had outstanding for some time. I did conduct a mediation via Zoom in December, and that mediation resulted in the settlement of many, but not all of the issues that the party has outstanding. And that resolution was entered by an order from this court maybe just a few weeks ago. So prior to that December mediation, the County of Jackson, through a fund that's been set up that's funded through marriage application fees, had been paying for my fees. I think that the county may have mismanaged that fund or may have not have paid attention to it, and it simply went, it's in the negative to the best of my understanding. And so I'm in a position where I have worked for the parties, helped them resolve their disputes, benefit out of the services that I provided, and I've asked them to each split my outstanding bill. The total outstanding bill I've got is $710. I only billed them for the actual mediation in December. I haven't billed for anything past that point, and I'm not billing anything now either. I understand that one of the parties, Mrs. Terry, has agreed to pay for half of that outstanding bill, and Mr. Terry has not. And so I'm asking the court to order that each of the parties pay for half of my outstanding bill, I think of $710, and they can use me in the future if they want to, and agree to pay for my services. And if they don't want to, they can be done with me. But that's my position. I'm hoping the court will grant my motion.
Okay, Mr. Terry, you oppose the motion?
I'm sorry, Your Honor, I missed that.
Do you oppose the motion?
I oppose the motion.
I appreciate the fact that you don't like getting a surprise bill. The reality is Mr. Phillips has performed a service and the county has no funds available from which to pay him. The only remaining resource from which Mr. Phillips can be paid is the resources of the parties.
I understand it, Your Honor. If I may, I can have my view, show my view.
Of course, go ahead.
Your Honor, at the time of the service, Mr. Phillips was, we were told that it was going to be paid for at no fault of his, that the County of Jackson stopped paying for this. Our mediation was conducted in December and was finalized. I gave verbal consent on Zoom as long as a email was sent to Mr. Phillips saying that I agreed to the mediation that was on 12/18/20. I got an email from Mr. Hotchkiss. I tried to inquire about what our status was it was in January. I finally got a response on February 23rd. Mr. Phillips, as he indicated, he suggested to me, I gave my verbal and email approval, but not has my actual signature. Mr. Phillips also indicated that he was not billed any time in this case since mediation, and he is willing to submit the order, prepare the report, serve the resulting order at no charge, just that he can get this things wrapped up. As you know, the county has stopped paying, but he said that he was going to pay for all this, and then now in March 29th, he turns around and files a motion to get paid when he already said that he would not bill for this service because it's a long outstanding procedure last year that we went through all summer, and he procrastinated and not got his paperwork in, and then they stopped paying.
I can tell you this fund has been depleted for several months. We were all very surprised to find that out. In any event, we don't have funds to pay him. He provided services. He deserves to be services that benefited the parties. He deserves to be paid. So I appreciate your frustration, Mr. Terry. I wish it weren't so. If the funds were there, I absolutely would authorize the county to pay them, but they don't have them. And Mr. Phillips deserves to be paid. I'm going to order that the parties split Mr. Phillips' LGAL fee of $710 equally. Mr. Phillips, you'll prepare an order to that effect?
Yes, sir.
Thank you. That concludes our hearing, folks.
Thank you.
Thank you, Your Honor.
You're welcome. I'm going to take a short break before I bring anyone back in. I'm just going to leave it running, but you can take us up the back. you hear anything from the IT guy?
Nope.
Okay, let's see, where are we? Fagin. Mr. Hilderly, how are you? I can't hear you, Brian.
Good morning, Your Honor.
Okay, that works.
Can you hear me now?
Let's see. Yeah, I can. I'm looking for the parties in Fagin. There's Jack Fagin. And I'm looking for an Alexis. I've got a phone number. Let me see who that is. Just let somebody in with a telephone prefix. What is your name? In the blue shirt and tie, can you hear me?
Yep. I'm sorry, Matthew Shaw.
Matthew, last name again?
Shaw, S-H-A-W, sir.
All right, I just put a name with your image. I will bring you back into the courtroom when it's time for your case.
Thank you, sir.
You're welcome. All right, so we got Mr. Fagin.
Yes.
And I'm looking for Ms. Fagin. I see I've got an iPhone. I got to find out who that is. I don't see anybody in here with the name, first name Alexis or last name Fagin other than Mr. Fagin. So let me see who's on this iPhone.
Your Honor, do you have a person named Matt Morris in there?
I've got a Matt Harris.
I thought it was, I had heard from a different attorney that he was coming in place of Ms. Fleming. I never received an appearance or a response to the motion, but, and I believe his name was Matt Morris.
I don't see anyone. Like I said, I see a Matthew Harris.
Oh, okay.
I can certainly, I can see who that is. So I let someone in with an iPhone. What is your name, please?
Alexis Fagin.
Oh, okay.
Hi.
I'll put a name on the file. And Ms. Fagin, do you have an attorney representing you here today?
Yeah, Matthew Harris.
Oh, it is
okay.
Harris.
Mystery solved. As soon as we get Mr. Harris in, we will go on the record. Okay, Shannon, put us back on the record, please. This is a matter of Fagin versus Fagin. Mr. Hilderly for the plaintiff, Mr. Matthew Harris, I don't have a written appearance, but you're appearing today on behalf of the defendant?
Correct, Your Honor.
Okay, and both Mr. and Mrs. Fagin are present. So we're here, I believe, Mr. Hilderly, on your objections.
That's correct, Your Honor.
Okay, and Mr. Harris, would you like to speak to those objections?
Yes, so the child support calculations, they weren't attached to the objection, so it's not perfectly clear what exactly the objections. But again, having read through it, I understand what he's getting at. And look, I acknowledge that if the objections were done, or I'm sorry, if the calculations were made with the incorrect number of overnights, then I do acknowledge that the child support should be recalculated, because as things currently stand, the parties do at this time have equal parenting time. And so that just is what it is. And I acknowledge that the support should be recalculated to reflect that they have equal parenting time at this time. However, as far as the effective dates and such, the parties didn't have equal parenting time until around mid-January of this year. So the entire first semester of school, the children lived primarily with Miss Fagin. And so I would, if the support amount is going to be changed to reflect the new parenting time arrangement, I understand that. But I would want the effective date to be around January, when the change of parenting time actually took place. Because again, during the entire first semester from school, the children lived with Miss Fagin. And they had, they spent weekend time with Mr. Fagin, of course, but he was the primary physical custodian during that time. And so while I can acknowledge that the, if the support is indeed based on an overnight structure that is not equal, then it should be changed to reflect that. But then, as far as the other objections, certainly as far as the, I think daycare expenses should be part of the formula. I mean, if you can show that there's daycare expenses for either party, then they get input into the formula. I don't see why that should be the case. And then secondly, I would object to the stimulus funds being equally divided for the same reason I spoke on earlier, is that the children lived with Ms. Fagin during this time when the stimulus funds were given to the parties. That's why I think she, quite frankly, deserves it. She was primarily taking care of the kids during that time. And so I guess that's the substance of my comments as far as the objections that were filed are concerned.
Well, the proposed order does award equal overnights. So let me ask you,
Your Honor,
Mr. Hilderly.
Your Honor, if I may, the key issue in the objection is that the order that was put in place does not say joint physical, even though the parties are exercising and you did award joint physical. And because it says joint legal but primary physical with Mrs. Fagin, it's causing a problem with the calculation, with the stimulus money, with everything else. So really the key issue in this is making sure that the new order says joint legal and joint physical, so that we can clear up any future issues. The other ones are sort of ancillary items that were caused as a result of the order saying primary physical with Mrs. Fagin when the court ordered joint. So that's really the main key issue, is making sure that it says joint physical to prevent any future problems. And then we were asking for some remedies as a result of the problems caused by the order saying primary physical. One being that the child support calculation is off, stimulus money was off. So we're just trying to get those things corrected.
Well, there's no question if there's equal parenting time, it should say joint legal and joint physical. I don't know why it says primary physical to a parent who doesn't have primary physical. That just doesn't even make sense.
That was not to talk bad about her when she's not here to defend herself, but that was an Ann Fleming argument that was made, and so I agree with you.
So how do I fix this?
Well, I guess we presented a proposed order. If you are awarding something short of everything we asked for, I'll certainly prepare a new order consistent with whatever your decision is today. But I think at a bare minimum, changing the custody arrangement to joint legal, joint physical, sending it back for a recalculation, whatever your honor thinks is the appropriate, I think it should go back to the date that the original order was put in place that said primary physical. That should be the retroactive date. I don't have it right off the top of my head, but so that at a bare minimum, we should be doing that.
I don't
know what your honor's position on the stimulus money is.
I don't see a proposed order, Mr. Gilderly.
I never received a proposed order myself either, Your Honor.
Okay. There's one in my file. I thought she sent it over. Maybe she just prepared it in anticipation. So if it's not circulated, then I do have one in my files. But if you don't have it, then that solves that problem. We can just present an order consistent with what you ruled today.
So look, I mean, I don't like, oh, go ahead, Your Honor, I'm sorry.
Certainly, if we're talking about calling this primary physical versus joint physical, that's an easy one for me. This is joint physical, and whatever order is entered should reflect that there's joint physical custody. As to effective dates, et cetera, I'm not clear on what proper effective date it should be. I'm not sure what you're basing your request to change the effective date on. Clearly, the proposed order says effective 3/1/2021. It strikes me that it probably should be earlier than that, but as to what is the correct effective date, I need to hear from both parties on that.
So Your Honor, I apologize. I thought you were done. I can refresh the court's memory on the timeline. We did have a trial on this matter. The court, it looks like, issued its opinion on September 25th of 2020. We did submit a proposed judgment of divorce consistent with that opinion. Ms. Fleming objected to that. Ultimately, the judgment of divorce looks like it was entered on December 7th. So those were the opinion of the court was September 25th. The ultimate entry of the judgment of divorce, it looks like, was December 7th. So I think either of those dates, December 7th may be the date. That's where the judgment of divorce was entered, and it should have said joint physical.
And so I guess, certainly Your Honor is of course correct with the how you label it. I mean, if they're doing 50 equal time, calling it primary to one party doesn't make any sense. And so, yes, of course, it should be joint physical and joint legal, as the court has indicated. And as far as my position on the effective date, the dates that Brother Counsel has given, I believe are correct in terms of when the opinion was issued and when the judgment was entered. I can just speak from the parties' practices, is that even though these decisions may have been made at prior dates, one in September, one in December, the parties' practices, again, Ms. Fagin was the primary physical custodian until the middle of January. And then that's when the parties started to do this new schedule that was, that was set forth in Your Honor's both opinion and the judgment of divorce. And so even though those things may have been entered at previous times, the parties didn't start practicing those things until into the new year. And so I think that probably makes the most sense, is let's make it effective when the parties started doing it.
Am I allowed to talk?
Sure.
All right. Well, no, we have been doing the 50-50 custody, which was court ordered all summer of last year, 2020. And at the beginning of the COVID shutdown is when we started the 50-50 summer custody that was in place at that time. So we've been doing the 50-50 custody since the beginning of last year.
That's not true. We didn't start the U5 schedule until Shelley, the guardian ad litem, gave us that order in June. And in August, we came up with another email from Ann and your lawyer going back and forth about what we were going to do. The first 2 weeks, Millie stayed with you and Corbin stayed with me primarily until Millie started school. And then you only took them every other weekend until the second week in January. Yes, that is true. And it was even brought up in court with Brian and made a statement saying that you're only taking them every other weekend. And your answer was that you didn't know it was effective.
Everything's on YouTube.
I know. You have not been taking the kids except for
Hold on. If everybody agreed that they started the new schedule in January, it'd be very easy for me to say, okay, let's make it effective January 1. But since they don't agree, how am I gonna, I got one party saying we did and one saying we didn't. Is there some independent proof out there to figure out what that is? Who's telling the truth?
I have been taking both the kids in school, and until January, Jake unenrolled our youngest from school because he didn't want to take her. So yes, Millie has been going, both of them have been going, and I have been the only one taking them until January when he unenrolled her for his days.
I don't think Mr. Fagin is saying that he exercised 50-50 parenting time during the first semester of school. I don't think that's what he was saying. He was saying he did it prior to that. But I don't think he's even saying that he did 50-50 during the first semester of school. I don't think he's even saying that.
Yeah, from June
Are you saying that? Are you saying that, Mr. Fagin?
I was saying
I guess I misunderstood you.
We practiced the 50-50. And then as far as the school, as soon as school started up this year, I'm in charge of the school. Tuesday, Friday, she gets them there Monday, Tuesday, Wednesday. Well, they don't go to school Wednesday.
All right, so here's the question.
Them to school, and we've been 50-50.
During the fall of 2020, did you, through the present, have you had the children 50-50? Well, that's what I heard, Mr. Harris.
Okay. I mean, okay.
So who can tell me who's telling the truth here and who's lying? Because I'm telling you, it can't be both. It's one way or the other. Ms. Fagin is telling me.
I had the children until January of 2021. He was only taking every other weekend. And in January of 2021 is when he
I know you're saying that, ma'am. I know that. And I know he's saying something else. My question is, other than the two of you, is there someone else who can verify which one of you is telling the truth?
The only ones that would be able to verify it is by me taking Millie to school, is what I was saying. which is why when he started taking his parenting time in January, he unenrolled her from school on his days because he didn't want to take her. Even though they're already taking Corbin to school, that's when he unenrolled her, is in January, when he started taking his 50-50 parenting time.
So you're telling me somebody at the school can testify? So I'm getting some feedback from somebody's phone. I don't know whose it is. Is it somebody from the school can verify that you were dropping and picking the
I have
kids
to
from school?
physically drop them off. Yeah, I have to physically drop them off and sign them in on a keypad. I have a pen for it that I have to sign them in at.
Your Honor, I signed them into the same ped.
But you're not the one that takes them to school. Harmony is.
But you're not signing a name.
No, you have to sign in with a pen and it pulls up the child associated with the pen. You don't do that because Harmony takes them to school and she gets in the drop-off line. She doesn't physically have to go in.
This is besides the point. Besides the point.
Your Honor.
It really is. Yes,
Your
Mr.
Honor.
Hilderly.
We're obviously not getting anywhere this morning with this. Why don't we, if that's the only issue that we need to address, and I don't know whether the effective date weighs in on your position on the stimulus money. But if that's the only issue, maybe Mr. Harris and I can work that out. And if we can't, we'll schedule a hearing at a later date. But I think I'm not sure that the effective date is really a main primary issue. If we're sort of settled on the idea of fixing the problem, I think that's much more important than 30 days of effective date. Because it seems like that's all we're arguing about.
I don't disagree with that.
Why don't we do that? So you already have my ruling as to the physical custody thing that you can implement. As to the effective date, if you can't work it out, just renotice the objections. Actually, could hold it on and get an hour of time so that I can get to the bottom of when this new schedule actually got implemented. If it was January, I'm going to make the order effective January 1st. If it was not, if that's what I end up finding, I would make the effective date September. So the opinion was September 25th. I would make it effective October 1. So it's one of those two dates. If you can figure it out, great. If you can't, I'm happy to resolve it for you.
Okay. Thank you, Judge.
All right. Thank you. Have a good day.
Thank you, Your Honor.
Okay. Don't do that one anymore. Let me see if Mr. Navarre, looks like he's disappeared. So maybe they resolved it. I'm just going to leave it there until he shows up again. I don't think I've got anybody in a breakout room.
The Schmucker PPO is on.
Oh, I do. All right, Phil's still in that breakout room. Okay, let's see, where are we? Bolton. Augustine versus Bolton. I don't see anyone on that one. Oh, wait, we have Carl Bolton. We let him in. Mr. Bolton,
Yes, Your Honor.
I'm looking for the other people associated with your case, and I'm not seeing anybody else. Who represents you in this matter?
Attorney Mark Bailey.
Yeah, I don't see. Is there another attorney from his office, a Patrick Bailey?
I'm not aware of a Patrick, Your Honor. There's a Matt Bailey. Your Honor, I did call his office about a half hour ago to see where we were standing as far as being seen. And he said he was still on the line waiting to get in. I'm not sure what's happened since then.
All right. And do you know if Ms. Augustine has hired an attorney for today?
I do not know if she is currently still being represented by him, but her attorney on retainer was Dennis Conant.
And normally representation ends upon entry of a judgment of divorce. So unless Mr. Conant was retained for this post-judgment relief, I wouldn't expect him to be here. But I do not see Ms. Augustine in the waiting room. I do not see your attorney in the waiting room.
Okay.
Let me just. I'm going to see if he perhaps is with this other phone that says Patrick Bailey.
Okay.
Sometimes I have lawyers sign in on their children's. There's Mr. Bailey. Morning, Mr. Bailey. Mr. Bailey, can you hear me? Obviously, he can't hear me.
I can hear you now, Judge, if you were talking to me.
Yes, I was. We were trying to find Mark Bailey. All I could see was Patrick Bailey in the waiting room.
Well, it's Mark Bailey. I don't know why it says Patrick Bailey, but you're stuck with me today.
Well, you know what? I'm going to fix that. It only lasts for this hearing, but you can change this yourself. And I recommend you figure out how to do that so you don't end up languishing in my waiting room. Okay, so you represent Mr. Bolton, correct?
That is correct, Judge.
I do not see Meredith Augustine in the waiting room. I do see one phone number. I'm going to see who that is. I just need someone in with a telephone number starting in 937. What is your name?
Amber Benton.
Benton?
Yes.
All right, Ms. Benton, I put a name on the screen, so I know it's you. I'm going to put you back in the waiting room till I call your case. Okay, and let's see. I've got a Jody's iPad. Who knows who that is? Half the time I get parents logging in on their kids' devices, and nobody seems to know how to change the screen name. I'm going to
find out. I didn't realize. Yeah, I didn't realize it, Judge, that it said Patrick Bailey. I apologize. Obviously, Patrick's my son in my office.
Okay, I'm going to find out who these other people are. I hate to proceed while somebody's in the waiting room. Ma'am, on the iPad, what is your name?
Jody Benton.
All right, Ms. Benton, I'm going to put your last name with this so I know who you are. And then I'm
Okay.
going to put you back in the waiting room.
Okay.
And let's see if we've got any other mystery guests today. You haven't heard from any other attorney on this matter, Mr. Bailey?
No, Judge, when we filed this on April 1st, I did send a courtesy copy to Dennis Conant, who was the attorney that represented Mrs. Bolton, now Augustine, at through the divorce proceedings. The only thing I have heard nothing from Dennis Conant, by the way, and I did receive an email from Meredith Augustine yesterday, just indicating that she got the motion and she didn't really agree to what we were asking for and gave me some reasons for it, but I haven't received anything for a formal filing from her or from Mr. Conant.
All right, well, I've got names associated with everyone that's in there. And she's not one of them. So go ahead with your motion to enforce.
Okay, thanks, Judge. Well, it's a pretty straightforward motion. The court entered a judgment of divorce on January 7th, 2021. And as we oftentimes see in these judgments of divorce, there's a requirement for one of the parties to refinance the mortgage, which is in both parties' names. That was the case here. She was required to either have the mortgage refinanced or list the home for sale if it hadn't occurred by March 1st. Now, March 1st of 2021, obviously today's date is April 15th, 2021. My client has had to, or tried to reach out to her on multiple occasions to find out the status. And until we filed this, received nothing in terms of a response. But as we sit here today on April 15, 2021, the home is still not refinanced. Now, I think it's fairly straightforward. She's indicated that she hasn't done it in that email that she just sent to me, stating that she's running into problems. This case had a remedy built right into the judgment, stating that in the event it's not done, it's going to be listed for sale with no reasonable offer being refused. So my client, who is renting a home right now, cannot buy a home because he doesn't qualify for refinance, or he doesn't qualify for financing because his name still appears on this mortgage. So what we're asking the court to order today is that our motion to enforce the judgment of divorce provision regarding refinance and be granted, that the home be immediately listed for sale with Mr. Brent Johnson of Century 21, who, it's my understanding, both parties are familiar with. He is located in Jackson, that both parties are ordered and directed to fully cooperate with the listing agent with no reasonable offers to be preserved. There was also an issue in this case regarding a 1999 Honda. My client signed over the title, but Miss Augustine, as she now goes by, has not bothered to enter it with the Secretary of State. So we'd like that to be included as part of the order. We've also asked for reasonable attorney fees because my client has had to hire me to carry forward this action to enforce the judgment of divorce. And, obviously Miss Augustine's not even present today. I've received nothing in a formal filing. She hasn't done what she's supposed to do. She should have done it without the need of my client having to hire me to file this motion. So that's in this essence, Judge, what we're asking for today. And I'd like to prepare an order depending on what you say and submit it under a 7-day order, so I don't have to try to obtain signatures from Mrs. Bolton or Miss Augustine, formerly Mrs. Bolton.
I will grant all the relief you've requested. You may submit an order to that effect.
As to the attorney fees, Judge, your thoughts on that? I have about probably 3 hours wrapped up into this. at $300 an hour. May I include a provision, and there's going to be the order and so forth, plus the time today. May I include a provision that she pays me $1,200 within 30 days?
And that would include your motion fee?
It would, yes. Motion fee and
Yes.
a cost for the order that I'm about to prepare in the 7-day notice.
Yes, you may do that.
Thank you, Judge. I don't have anything else.
You're welcome. Have a good day.
Thank you. Bye now.
Thank you, Your Honor.
You're welcome. Have a good day, sir. And open. Roby's done. Cole Lundquist. There's Marcia. Good morning, Marcia.
Good morning, Judge.
All right, I see Cole is logging in. Let me see who else is here on this file. Who should I be expecting?
Oh, there's, I don't know who that is. This is Mr. Carroll's case, so I believe Elizabeth Carr. I don't know if that's who that was in the screen or not.
Is that the mother?
Yes, that's the mother.
All right, let me unmute. Anyone other than the juvenile, his mother and yourself?
Larry Wen is dad. I don't know his level of participation. I know that Cole, I believe, sees him on weekends, but I don't know if he's coming today.
His father hasn't been involved in past hearings. Cole, can you hear me?
Yes, Your Honor. Can you hear me?
I can. Is your mother present with you?
I think she's waiting for your call, Your Honor.
Yes, she
All
was
right.
participating via phone.
Oh, okay. I think I saw a note to that effect. Well, maybe Chad just mentioned it to me. I don't see. Let me see if I can find a phone number.
I have.
Yeah, come to think of it, that is how I involved her the last time. I think she was at work. Go ahead with that number.
392-8380.
8380. What's her name?
Elizabeth.
Please leave your message for 51739283880.
I thought she was waiting for the call.
Is she at work, Cole?
Yeah, that's possibly why. She possibly was waiting at 9. It's 10:30, and she only has a certain amount of time to be on her phone or around her phone.
Is Mr. Hotchkiss here?
I think he was here earlier. I do not see him now. So I'm going to have to put you back in the waiting room. As you might tell, I've had a very busy docket this morning.
Yes. Yes, sir.
They tend, when I happen to be gone on a Thursday, instead of spacing things out, they dump everything on the next week. I was gone
Right.
two Thursdays in a row, and it looks like they piled 3 days worth on this schedule. Sorry to keep you waiting. I don't have any choice. I need Mr. Hotchkiss present. He's likely in another courtroom. I'll put you back in the waiting room and I'll watch to see when he shows up.
All right, Your Honor. Thank you.
Sorry, Marcia. And I got some pre-trials. Ramos, Lugo. And let's see. Looking for Mr. Ramos Lugo, you can hear me?
Can you hear me?
Okay. I can.
Good morning, sir.
Good morning. Sorry to keep you waiting. We've had a busy docket this morning.
Oh, you're fine.
I'm looking for Carly. I don't see anybody with that last name or with that first name. Unfortunately, sometimes parents log in on their children's devices and their children's names show up on the screen. What are your children's names?
Our daughter's name is Sophia, but she's only one.
She doesn't have a computer yet?
I'm not sure, but I know it's possible to use
I'm teasing you, sir.
Oh, okay. No, she doesn't have a computer or a phone yet.
All right, so it's not in under a child's name. Yeah, sometimes it's under a friend's name, but I'm not seeing anything that looks remotely like it could be her. So your case is scheduled for a pretrial today.
Okay.
What happens at a pretrial is I try to figure out whether there's going to be a need for a trial.
Right.
Issues that end up in trial in divorce cases are division of property, custody, parenting time, child support, and spousal support. You folks have a temporary order in place that addresses custody, parenting time, child support, and it doesn't give you any kind of specific parenting time. Has she been letting you see the child?
Right. Well, the thing is I don't live in Michigan. I'm residing in Tennessee right now.
I see.
But when we discussed, going through with the divorce, we both filled out the paperwork together. And pretty much what we discussed was, my daughter was going to live with her. And then I would be able to get her 2 or 3 months out of the year. So typically the summertime. We wanted to try to keep it consistent. So when she does start school, she's already in the habit of being there through the school year, and then coming to be with me, for those 2 or 3 months. And then, of course, alternate the holidays, as we can agree or as possible. I don't live.
It sounds like this temporary order has been working out okay for you.
Well, the temporary order, I actually honestly didn't know anything about it till recently. None of the paperwork got mailed to me within the amount of time for me to even dispute it if I wanted to. But I did receive it. From the time that I received the paperwork, there was really nothing I can do about it. I was going off with the hopes and the trust of what we agreed upon, just with the hopes that she's not going to turn around and go back on what we discussed. Everything that we discussed.
Let me lay this out for you then. So this is just a temporary order. In order for me to grant a final judgment of divorce, I either have the parties appear for a trial and I decide what the custody arrangement, parenting time is going to be going forward, or the two of you agree, and then you submit a proposed judgment of divorce to me.
Okay.
And I can, assuming I get proofs established on the record, I can go ahead and enter that. I don't know where she is today. If she's in my waiting room, she's in there under a different name. So there's too many people in there. I'm not going to try to figure out who's in there right now. You're scheduled for trial April 29th, it looks like, at 1:30. If you guys can work things out before then and do a consent judgment of divorce and have it ready for me then, I could enter it. If you're not, if she doesn't show up and you're the only one here, I will take testimony from you and I will enter a judgment of divorce consistent with your testimony.
Okay.
Well, just a minute. Hold on a minute. So she's listed as the plaintiff, but what you're telling me is you both filed this paperwork together?
Yes. The thing was just to give you a little background, she ended up, I guess things weren't working out. I wasn't aware of it. She ended up stepping out of the marriage. And then they wanted me to move out within a month, which that wasn't possible, due to the coronavirus, and I wasn't working and just a bunch of different things. I got played out dirty, period, by her and her grandmother. But anyway, when we discussed the divorce, she's never been through it before. And not sure if you remember me, but I've been through this before with you as well. So I kind of told her about how it would go, and what she proposed was she wanted us to both, fill out the paperwork together. That way, we could submit it together, and that way she would have some security that I wouldn't be trying to take my daughter from her. Which, I said it was fine because I wouldn't do that. I'm an easygoing guy. So we both discussed it, and while we were typing up the paperwork or entering it on the computer, we were both there. And like proposed on the paperwork, she wanted my daughter to live with her, and then I would get her 2 or 3 months out of the year. And I also agreed to pay the child support, once that went through. And and that was pretty much it. And like I told her, I don't want to give up my rights, of course, because I still have my rights to, all my kids. I love all my kids.
So let me stop you, sir. I see I've got a phone number for her in the file. Let me see if I can get her on the phone.
Okay.
The number you dialed is not a working number. Please
I have
check the
her number here, if you'd like.
Why don't you yes, please give me that.
Okay, it's 517-917-8163.
We're sorry, your call cannot be completed at this time. Please hang up and try your call again later. Thank you.
Let me send her a message. Yeah, I kind of wanted to get it set, you know, with what we agreed on me getting her, you know, for the summer or the 2 or 3 months. Because for a while there, you know, we would talk on a daily basis. Shortly after I left, and I would video my daughter, you know, on a daily basis, or, you know, if my daughter was, you know, when she started pulling herself up on things, you know, she would tell me and stuff like that. But then she started dating this guy, and then it just seemed, I don't know what kind of relationship they got going on. But then the messages and the phone calls and me being able to video her, you know, when I was not working, became a problem. So she told me to, you know, video her, you know, at 7:30, you know, when I do call. But the thing is I work at night and in the afternoon. So calling at that time is kind of hard.
So let me stop you, sir. You're scheduled for trial. Tell me all of this at the trial.
Okay.
If she's not here, we'll move forward without her. Make sure she knows she really needs to be present.
Right. Okay.
She
Yeah.
wants this divorce. She needs to be present at the next hearing, but not in person, but by Zoom. She can call in or she can Zoom in.
Okay.
But she's got to be present in order for me to be able to move forward on this.
Okay. All right. Definitely.
All right. Thank you, sir. Have a good day.
Thank you for your time. You too.
You're welcome.
Bye-bye.
Hey, Peter.
Morning, Judge.
Hey, Peter.
Morning, Shan.
So, do we have Matthew? Nope, we don't. So what else we got? Another pretrial, it looks like. Shaw versus Shaw. Let's see if we have any Shaws here. Matthew Shaw. And a Taylor Shaw. You are Matthew Shaw?
Yes, sir.
All right, I'm looking for Taylor.
Just
I've
text.
got a Taylor Luce.
Yep, that's probably her
All right.
email address or whatever.
All right, we'll let her in. Okay, so this is the matter of Shaw versus Shaw. Mr. Taylor's present, and Mr. Shaw is present, and Ms. Taylor Shaw is also present, correct?
Correct.
Okay, so we're set for a pretrial today. I've got a note here that looks like you folks have tried to get a consent judgment of divorce approved, but there was some missing information on it. Let's see if we can't fix all of this. I'm assuming you want to be divorced today. Is that correct?
Yes, sir. Yes, sir.
All right. Okay. All right, well, let me take some proofs from you, Ms. Shaw. Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your full name for the record.
Taylor Ann Shaw.
Ms. Shaw, you filed a complaint for divorce back in October. Was everything in that complaint true at the time that you filed it?
Yes,
And is it still true today?
yes,
It appears that there are 2 living minor children born or adopted during your marriage to Mr. Shaw. Kinsley, and Kaylee. Is that correct?
Yes.
And no other children were born during the marriage?
No.
Are you pregnant today?
No.
Is there any possibility of you and Mr. Shaw reconciling?
No.
Okay, I've got a proposed judgment of divorce. Let's see, an order exempting you from friend of the court services. You've opted out of friend of the court involvement, is that correct?
Yes.
And let's see. Has there ever been any domestic violence in your relationship or any unequal bargaining between the two of you?
No.
No,
Do you believe that opting out of friend of the court services would be in the best interest of your children?
Yes.
yes,
And let's see, I think you both have already acknowledged receipt of your advice of rights. I see something here with signatures on it. You both did sign that?
yes, sir.
Yes.
Neither of you is receiving public assistance?
No.
No, sir.
Is there any money due to the government for past public assistance?
No, sir.
Has there ever been a custody or parenting time order in place before whatever was entered in this case?
No, sir.
No.
All right, so I can approve that. I've got a proposed judgment of divorce. It appears that you both reviewed and signed it. You believe the terms and provisions are in the best interest of your children?
Yes, sir.
Yes.
Okay, and do you believe the provisions for division of property, et cetera, are fair and equitable under all of the circumstances?
Yes, sir.
So you did submit an income tax addendum, but you didn't. Oh, wait a minute. Hold on a minute. Looks like you're splitting the exemptions. One of you is going to take Kinsley, and the other is going to take Kaylee.
Yes, sir.
Beginning in 2022. All right. I don't know if I asked you this. Is there any possibility of the two of you reconciling?
No.
No, sir.
All right. I am satisfied based on the proofs that there's been a breakdown in your marriage. To the extent that the objects of matrimony have been destroyed, there remains no reasonable likelihood your marriage can be preserved. I'm going to sign your judgment of divorce, and you are divorced effective today. Any questions for me?
No.
No, sir.
All right. Sorry to keep you waiting. We'll get this paperwork to you as quickly as it can be mailed out.
Okay. Thank you, sir.
Thank you.
You're welcome. Good luck to both of you.
Thank you. Do we just disconnect, sir?
Yeah, you can just disconnect.
Okay. Thank you.
Phil, let me finish signing some things here, and we'll call your case back up.
Thank you, Your Honor.
Peter?
Yeah.
You can put this in Dawn's box.
Okay.
That'll save me from writing a note on it. Thank you.
You're welcome.
And Mr. Hotchkiss wasn't here. Okay, Phil, let me bring the other parties back in. This is Carnell, correct?
That's correct, Your Honor.
I think they're still in there. Well, she is. Looks like we might have lost him.
Yeah, Judge, I was never put in a meeting room with them. I was just in a separate room. So I did have an opportunity to speak over the phone with the plaintiff, Randy Campbell, and we have reached an agreement regarding a temporary order.
Oh, okay.
And so what we've agreed to is every Wednesday from 2:30 to 7 p.m. For parenting time with Mr. Carnell and the kids. And then alternate weekends starting May 1st from 2:30 to 7 p.m. And the oldest son, Isaac, will have a cell phone and he'll be able to have access to that. My client's parenting time if he needs to communicate with his mom, Randy Campbell. And my client will also have reasonable daily phone contact with the kids after 7 p.m. during the school week and on weekends where he's not exercising his parenting time. And that my client will follow any kind of recommendations that may be made regarding the children with the children's counselors. That if the children wish to spend Saturday overnight with my client, they may do so. We have talked about transitioning, and this Saturday they're going to meet at Cascades Park at 2:30. Because the oldest child is been diagnosed with autism, PTSD, ADHD. He's receiving services. He's got an IEP, and he receives ABA services as well during the week. My client will follow any kind of recommendations that are made regarding Isaac, and also any recommendations with Eden, who's also in counseling. So that's the understanding. Either party can come back at any time without filing a new motion. It's the intent to transition to alternate weekends from Friday at 6 to Sunday at 6, but I think that this is an appropriate first order for a phase-in reunification with my client and the children. And I think that the plaintiff is open and willing to have communication regarding the children with Mr. Carnell to further what's in their best interest. And I think that, obviously she is in the best position to know what is in their best interest as the primary custodial parent. So that's my understanding of the agreement. Randy, have I accurately communicated that to the court?
Yes. One thing though, Isaac is also diagnosed with severe separation anxiety. But yes, I agree with everything that you just said.
So, Mr. Carnell, my apologies. I didn't bring you right back in. I didn't see you initially when I looked at my waiting room list, but your attorney, Your attorney has placed on the record the terms of the agreement that you were able to reach with Ms. Campbell. She's confirmed that those are the correct agreement, correct terms. Mr. Navarre, you'll be submitting a consent order consistent with what you placed on the record here today?
I will, Your Honor, and I've discussed that with the plaintiff, Randy Campbell, and I will be emailing a proposed order to her for her review. And if it accurately reflects what we put on the record today, which it will, she's indicated she'll sign that on a consent basis, and we'll enter it on a consent basis. And so it's my understanding that she and Mr. Campbell and the kids are going to meet this Saturday, even though it's not part of the court order, so that they can transition to spending time with their dad. And so it'll be just the four of them that will meet this Saturday at Cascades, is what we had discussed. And then, you know, even though it's not part of the order, next Wednesday, the 21st, I think that they'll have some additional time on a consent and voluntary basis with their dad. And then we'll transition to starting the Wednesdays per court order on the 28th, and then alternate weekends, Saturday and Sunday on the 1st and 2nd of May, and every other weekend thereafter. So again, either party can come back to court with just a request or notice without filing a new motion to have further input if necessary from Your Honor to move to the next step in phase and extending my client's graduated parenting time. So that's the agreement.
Thank you.
That I agreed with the plaintiff, and I will prepare that order and we'll get that submitted, Judge.
Mr. Navarre, I want to thank you for your assistance this morning and helping the parties to resolve this. And I want to thank the parties. I want to encourage you also, Keegan, it's very important that you be consistent.
Yes, Your Honor.
When kids are expecting to see their dad and he doesn't show up, sometimes it's pretty upsetting. You need to be consistent.
Yes, sir.
I appreciate the fact that you both seem to be reasonable people, and despite the fact that you're not together as a couple, whatever differences you have, keep them away from the kids. Do your very best when you're around each other and the kids are around to show respect to the other parent. Your kids will really benefit that, and particularly in, is it Isaac? I remember the name correctly?
Yes.
That's right.
In Isaac's case, he's not going to be able to handle conflict at all. So it's just very important, even when you feel upset with Randy for something she said or did, or vice versa, to do your very best not to show it. Your children will benefit. Thank you again for your patience and your willingness to work through this morning. I wish you both well. Mr.
Thank you,
Navarre,
Your
I look
Honor.
forward to that order.
That
Have a good day,
concludes
folks.
my matters, Your Honor. Have a good day, Your Honor. Keegan,
Thank
I'll
you.
give you a call on yourself. Randy,
Sounds
thank you
good.
for your consideration.
Thank you.
Thank you all.
Thank you. Thank you, Randy.
Thank you.
Okay. Looks like we're ready for Dutchery, although I only see Bill here. Oh, there's Austin. Good morning, Mr. Rapley. I think it is still morning. Yes, it is.
Couple more minutes.
And Mr. Austin Dutchery is present. And let's see. Let me see if Kristen is present. I don't see a Kristen. I see a Christine, but a different last name. Mr. Rapley, you do represent the plaintiff, correct?
Correct, Your Honor.
All right, well, I can proceed with a pretrial without her as long as I have her counsel here. Does a trial appear likely?
No, Your Honor. I think my client was just trying to work through some personal property issues during the pendency of this matter. We did try to reach out to her earlier in the week to find out the status of that. If the court would just keep it on the trial date, I believe that we will be present with a agreed upon judgment.
Okay, we will do that. Sorry to keep you for so long. It's been a very busy morning.
Not a problem.
Have a good day.
Thank you.
All right, I gotta take another short break, Shannon. Take us off the record. Right?
Did that one finish? Did that one just finish right now?
Yeah.
Oh, that was fast.
Well, we're not done, but
Are we just taking a break?
yeah.
Gotcha.
What a morning.
Looks like you had a busy morning while I was gone.
Yeah, and I'm still way backed up.
Yeah, I've been calling people here, letting them know that. Are there any files here that I can get out of your way?
I'm not gonna pay any attention to them now.
Okay.
I'm gonna finish up what I got.
Sure.
Let's see.
You want me to call Shannon now?
No, she's not. She's across the hall.
I see.
Can you see if you can get a hold of Matt Hotchkiss?
Yeah, sure.
He's supposed to be here on a juvenile matter. I don't remember seeing him at all today. I've had a lot of people in and out of my waiting room, but I don't remember seeing him if he was there earlier. All right. Ramey. Got a Christine Ramey.
that is seriously hilarious. I've never seen that.
What, his profile?
Yes, that just made my whole freaking day.
Professional looking.
Okay, Ms. Ramey, good morning.
Hello, how are you?
Good. Sorry to keep you waiting today. We've had a very busy docket today.
I was afraid that maybe I was afraid that maybe I had done it incorrectly.
Just a second, Shannon. I don't see Mr. Ramey. Were you expecting him to be present?
I could not tell you.
He
I
asked
have
for-
not spoke to him.
Ron said he asked for an adjournment because he's very ill.
Oh.
Are you serious?
My clerk just informed me, put us on the record now, Shannon. So this is the matter of Ramey versus Ramey. Ms. Christine Ramey is present. My clerk just informed me that Mr. Ramey contacted my secretary this morning and asked if the matter could be adjourned because he's not feeling well.
Typical.
I can put this over 1 week. And we could try again next Thursday. That would be the 22nd. What I do at a pretrial, ma'am, is determine whether or not there's going to be a need for a trial. In a divorce where there's no children involved, the divorce, what's contested is typically property issues, sometimes spousal support if either side is seeking that, but typically property. Have the two of you already divided your personal property?
We didn't really have anything together. We rented a home. We each have a vehicle. The only issue is the 2008 Suzuki Boulevard, which in fact I gave him cash for on New Year's Eve of 2019, where it came into 2020. He was going to get money from me one way or another because it was right after our motorcycle wreck. So we had gotten a little bit of money from that. I was in Virginia with my daughter and for her other grandmother's funeral on her biological father's side. And he wanted me to pay rent. We made an agreement prior to us even getting the check that we would each spend X amount of dollars on bills. And I held up to my end of the bargain and he didn't, and he wanted me to pay the rent. And I said, no. Well, it continued and continued. And finally, when I got back, he asked me and I said, no, I'm not going to pay it. He said, well, how about this? You give me $350 and I'll give you the title to the bike. And I said, I'll give you $300. He went and got the title, came back into the bedroom where I was doing like a craft project. He handed me the title. I said, it's not signed. He said, we're together, aren't we? And I said, it's not signed. Then he signed it. He handed it to me. I looked at it. I said, you didn't print your name. He said, you can do that. And I said, no, you need to print your name. So now he did that. I give him the $300. He said, you weren't kidding, were you? And now I don't know if you can see his reply to, or his answer to my complaint for divorce. Everything in that is a lie. The only thing that is true is the date that we got married and that I did not work prior to us getting married, but I was also going through the steps to try to obtain disability at that time. I was in the appeal up process.
All right, ma'am. So we'll just put this over 1 week, April 22nd at 9:30. If he doesn't appear then, I'm going to go ahead with the trial date no matter what on April 29th.
Okay.
I'm going to give him the benefit of the doubt that he is indeed not feeling well today, but we'll see you back here in a week and hopefully my schedule won't be quite as full as it was this morning.
Oh, that's okay. I understand. I'm sure with everything having to go to this is got to be difficult. So,
Have a good day, ma'am. We'll see you in a week.
okay. Thank you so much. Appreciate it. Bye-bye.
You're welcome. So this one's off, I'm told. And what's this? Herrera versus, hey, there's Matt Hotchkiss. Let's do that. Marcia and Cole. Good morning, Mr. Hotchkiss.
Good morning, Your Honor.
Okay, Cole is present.
My
Marcia
mom
Hammond's
is
present.
actually waiting for your call now, Your Honor.
Oh, okay. Give me that number again.
It's 517-392-8380.
All right, I'll call her right now.
How you doing today, Mr. Yes.
Hello.
Good morning. This is Judge LaFlamme. Is this Elizabeth Haar?
Yes, sir.
Okay, we have Cole present by Zoom. We have his attorney, Mr. Hotchkiss, present by Zoom. And we have Marcia Hammond present from Juvenile Probation. So we're here today for entry of a dispositional order. Let's see. I have a dispositional report that's been submitted to the court. Ms. Hammond, I understand that someone else prepared this report, but you have it with you and you're familiar with its contents.
Yes, Your Honor.
Mr. Hotchkiss, did you receive a copy of the report?
I did receive a copy, Your Honor. I attempted to contact Mr. Lundquist, and I apologize, Cole. I had the wrong phone number for you, so I couldn't speak to you about the contents. I'll just ask, Your Honor, on the record, Cole, after reading the dispositional report, I know Ms. Hammond went over it with you. Did you have any questions or concerns about what it contains?
No, sir.
Okay, then I feel prepared to proceed, Your Honor. I have reviewed the dispositional report and its terms, and we are in agreement with both the narrative and the recommendations contained therein. Thank you.
And Ms. Hammond, do you have anything to add to the report today?
I do not. Mr. Farrell prepared this and went over it with Cole, and it looks appropriate to me.
Okay, and the narrative I have indicates the circumstances that led to this petition, an argument between Cole and his girlfriend. During the argument, there was an assault, and Cole was ultimately restrained by his stepfather. At a pretrial that occurred on March 25th, the court accepted a plea under advisement to petition 2. If Cole successfully completes probation, petition 2 will be dismissed. The recommendation based upon the risk factors and the nature of the petition is that Cole be placed on intensive supervised probation. The terms of the dispositional order will include that you remain on probation until July 15th of 2021 in the custody of your mother. That
Yes,
you
Your
report to your probation officer as directed and participate in any programs necessary, comply with all state, local, federal laws, not leave the state of Michigan without prior approval, that you attend school regularly with good behavior and effort, that you obey the reasonable rules of your parents and a curfew of 10 p.m. weekdays and weekends, that you submit to random screens and be responsible for the costs, that you not use or possess any illegal drugs or alcohol. If there's a positive drug screen, you'll need to obtain a substance abuse assessment, cooperate with recommendations of that assessment, and be responsible for any costs of treatment. That you not have contact with any juvenile or adult who has ongoing court involvement. That I've indicated earlier, placed in intensive supervised probation and follow the requirements of that supervised probation. That you obtain and that you become involved and maintain counseling. Your failure to comply with any of the above terms will subject you to secure detention. This will involve assessed fees of $150 for probation oversight, $25 for a crime victim assessment, a state minimum cost of $50, and reimbursement for your attorney of $200. There's also a requirement to reimburse the child care fund at the rate of $20 per day if placed in at the youth center or another out-of-home placement. That doesn't appear likely unless you violate terms of your probation. Did you have any questions about any of these dispositional terms, Cole?
No, Your Honor. I've run over the report multiple times, and I understand everything. So, no questions, Your Honor.
And Ms. Haar, did you have any questions about the terms of the disposition?
I actually have
the
report right here.
Okay.
No, I do not, Your Honor.
All right. Well, where's my order?
I just want to say sorry about the connection issues I was having earlier.
That's all right, no problem. Okay, so I'm going to approve these. I find that they indeed are in Cole's best interest. Oh, it looks like I missed something. It's just a reference to the plea under advisement, reflecting that 93 days of detention will be held in abeyance pending successful completion of the other requirements. So I am signing that order now. We'll make sure everybody gets copies of the order as entered. Any questions? Anything else that I need to place on the record today?
No, Your Honor. Thank you for your time.
Thank you. Cole, I wish you well.
Thank you,
I hope
Your
I
Honor.
don't see, I hope I don't see you again except under pleasant circumstances.
Yes, Your Honor.
Good luck to you,
Thank
sir.
you for your time,
Yes,
Your
Your
Honor.
Honor.
You're welcome, ma'am.
Yes.
Everyone,
Thank you for
sorry to
your
keep you
time, Your
waiting
Honor.
so
Have a good
long.
rest of your day.
I should say sorry to everyone except Matt for keeping you waiting so long.
Duly noted, Your Honor.
Only because I didn't keep you waiting. Okay,
No,
thank you.
thanks.
Have a good day, everyone.
You as well.
Bye-bye. This will eventually go back down to probation, juvenile probation. Okay, let's see, what else we got here? Dutch remain. Schmucker went away. Herrera v. Herrera. Motion to terminate. Okay, do I have any parties here?
Is that on the Benton matter?
No, it's Herrera versus Herrera. And I don't see anybody here. I don't see an appearance. I don't see anything. So this was here on a motion to terminate the PPO. Since there's nobody here, I won't be terminating the PPO. There's an order in here. And let's see, next is Benton versus Benton. Looks like I got a couple Bentons here.
It's also like Deputy Jacobson involved in this case. He should be in the waiting room.
Hello?
This is a matter of Benton versus Benton, and I'm sorry, Peter, what were you asking me?
There's a Deputy Jacobson who's involved in this matter.
Oh, okay.
He should be in the waiting room.
I see L. Jacobson. Is Ms. Denke involved?
She's attorney for a defendant.
Oh, okay. I didn't see her on the. Oh, yes, she is there. All right. Let's hold on. We'll make sure we get everybody in here. Okay, I think I've got a connection with everyone. This is a matter of Benton versus Benton. Oh, all right. Okay, and I do have, looks like Ms. Amber Benton, I've got you in here twice. We can see your image. Can you hear me? Can you hear me with the telephone connection?
Yes.
All right. Well, if we get an audio connection with the other device, I'll hang up the other so we don't get a feedback loop going.
Okay.
Okay, and let's see. This is a motion to terminate the PPO. Ms. Denke, who do you represent?
Judge, I represent Jody Benton. I believe this was an ex parte PPO that was issued.
Okay. All right, well, I'm not going to wait for that connection since Amber can hear us over the telephone connection, so we'll go with that. So when I have a PPO that's been issued ex parte and I see Judge McBain issued this particular PPO, and there's a timely motion to set it aside, the burden is on the plaintiff to establish to the court that circumstances exist which would justify continuation of the personal protection order. So I will first hear from Ms. Jody Benton. Before I place you under oath, ma'am, let me ask you, is it your desire to continue to keep this PPO in place?
No, I need to get into my house so I
No,
can move.
Jody, you're not
Oh.
the petitioner.
Oh.
Amber is. It
Okay.
may
I'm
assist-
sorry.
Okay,
Yeah.
I'm sorry.
It may
I'm
assist Ms.
sorry.
Benton to know that her in-laws are hoping to close on a new house tomorrow and would be able to be moved out of the home that they were sharing with Amber Benton by May 1st.
All right, so
if they're
I'm
moving
sorry.
out,
I
that may impact her decision.
I confused the parties. So Amber Benton, do you believe it's necessary to keep a PPO in place?
Yes, I do. I don't feel safe.
All right, fair enough. Raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your full name for the record.
Amber May Benton.
Ms. Benton, what is your relationship with Jody Benton?
That would be my husband's mother, so she'd be considered my mother-in-law.
And did the two of you reside in the same household for some period of time?
Yes, she's supposed to be living in the basement, and the agreement was for them to stay down there and not to come up to our part, but it hasn't been that way, and it's been rough for the past year.
What is it that Jody Benton has done that you believe requires the court to issue a personal protection order or to keep one in place?
Well, she's actually verbally assaulted me numerous times. One was actually over her niece that me and my husband did not want here at our house because of her drug use.
Whose house is this?
First. Huh?
Whose house is this?
Mine and my husband, Sean. Our names are the
So-
only ones on the page.
All right, and at some point after you acquired ownership of this home, you allowed his mother to move into the basement.
Yes, my husband felt like he had to do that, like he was obligated because they had sold our house before we bought our house.
I don't understand that. Explain that to me.
So, okay, in Ohio, me and my husband had decided to move to Michigan for it to be a better place for my daughter because of the drugs back home. Well, we were looking for a house and we decided to sell our trailer. So we moved in with them thinking it would be okay. But the first incident that started with Jody, she had kicked me while I was holding my daughter, and my husband was there to witness that. He saw it. So he got me and my daughter out of their house. And then before we could even say anything or deny this house, they had already put their house up for sale and sold it. So my husband felt like he was obligated to make sure his parents were not homeless.
So who else besides Ms. Jody Benton resides with her?
David Benton, her husband, my husband's father.
So you referenced a physical incident occurring when you were in Ohio where you say she kicked you.
Yes, my husband.
Have there been any physical incidents? Yeah, obviously, whatever happened as a result of that incident didn't keep you from allowing her and her husband to move into your present home, correct?
That I did not have a decision on. My husband did it because he felt like he needed to help his parents.
So are you telling me you weren't in favor of the decision, but nevertheless, they moved in with permission?
Yes, I did not want them to. I had stated that back in Ohio. I did not want them to move in with us.
All right. Now, since they were living with you here in Michigan, what, if anything, has Jody Benton done in the nature of either verbal or physical assaults to you?
So there's actually quite a few times. One, it occurred last year when her husband had that stroke. And the reason that one occurred was because we did not want her niece up at our house due to her drug use, because her niece uses heroin and meth. And we had told them that, and she got very angry, and she had actually swung on me while I was holding my daughter then. And then after that, she allowed her to come to our house. She brought her niece to our house without our permission after we had told her not to. And then I do believe it was January 1st, she had scared off our puppy. He was 6 months old. She was using a broom or a shovel or something and banging on the ice at 7:30 at night, and that scared him off. Well, then she had threatened to kill me. I'm not the only person she has threatened to kill. And my husband can testify to that also. Another incident was when I was in the garage, and she forced the garage door open and smashed my finger in the door. And my husband was standing right there and seeing it all. So I have him as a witness for that. And I also have a witness for her trying to get into my back door that was locked.
Anything else that she's said or done that you believe requires continuation of a personal protection order?
And when she threatened to make me have a miscarriage. And she knew I was pregnant.
When did she do that?
That, I do believe, would be on March 30th.
Anything else that you'd like to tell me?
And about her trying to break into my house, up into our part of the house.
Well, tell me about that.
So my daughter, she was asleep on the couch, and I have 2 dogs, and they've been very protective over me since I've been pregnant. So I lock every single door in my house. I have to lock every door. And since the back door to the deck was locked, she says that we destroyed a gazebo, but during the winter, since the gazebo was set up, the snow, because of how heavy and the weight of the snow was, it broke down the gazebo. So my husband had to take it down. Well, she was coming in trying to get the door, but she had told Officer Jacobson that she went to go look for the screening for the gazebo, which that is not true. The screening and everything to the broken gazebo was at our back door where our laundry room is, nowhere near the sliding doors. And my male dog does not have any clue who she is. He does not know her. And if he sees somebody trying to break in, he's instantly going to try to protect me and my daughter.
So this part of the home that Ms. Jody Benton was living in, does it have a separate entrance?
Yes, it does. They have their own key and everything.
Ms. Denke, do you have questions of Amber?
Thank you. Did your in-laws, Jody and David, give you $20,000 as a down payment for the house that you're currently living in?
They did not give it to us. Me and my husband, Sean, did not know that they were going to give $20,000 towards our house. They did that without me and my husband knowing, as a gift.
Okay, so you were buying the house expecting to spend $20,000 more, but when you got to closing, there was $20,000 already there?
Yes, it was $20,000 less.
Okay. And then they're living basically in an in-law apartment, a downstairs apartment, is that right?
Yes.
And you can access, And you
I'm
can
sorry.
access that apartment through the garage or by walking all the way around the house and up the hill. Is that right?
There is no hill, actually. The only hill there is when you have to go through the garage.
You can access the downstairs apartment through the garage. Is that right? What?
Either way, yes. Yes.
Okay. And this personal protection order prohibits Jody from being there. It's essentially made your in-laws homeless. Is that right?
I don't know if they're homeless or not. They have family and stuff.
Okay. You have said that, well, they can't get in, Jody can't get into her apartment and get her stuff with this PPO. Is that right?
She actually can with having sheriff here.
If she can arrange to have a sheriff stand by while she packs and moves an entire apartment.
Yes, that's exactly what it is. She did
Because
not
you would agree
I'm
that
sorry.
David, because of his heart attack and his health issues, isn't in a position where he could pack and move an apartment.
No, I don't agree with that.
Okay.
They said that they were having their oldest son, Chris, and his friend come up to help pack and move. And her husband is able to drive a car, lift heavy groceries. He is able to do all of that. I've seen it.
Let's focus now on your allegations. You said that on the 29th, you have a witness to her trying to break into your house. Is that right?
Yes, I do.
Who is that witness?
I was video chatting with Jerica Hartwick, and she watched the whole thing.
On video chat?
Yes, she did.
Okay. You didn't put that in your motion. Is she available today?
I'm not sure. I didn't have an attorney, and now I was allowed witnesses.
Okay. On the 30th, you said that you were talking to your dad and Jody started yelling and screaming at you.
Yes.
And you weren't yelling at her. You and your dad weren't calling her foul names, were you?
I didn't call her a foul name. I told her to leave me alone, and she was irrelevant towards me. And she just kept going.
Were you
exactly every time? I've told her to leave me alone every time and stop yelling and screaming at me. My husband has witnessed numerous of times of her doing this also.
Ma'am, were you swearing at her?
I don't remember if I sweared, but I did tell her she was irrelevant.
Was your father also calling her names?
That I did not realize my dad was, if he was, but I cannot control my father. My father is a 70-year-old man.
Your complaint was this was taking place in front of your daughter?
Yes, it was.
Would you agree with me that all three of the adults in this conversation, Jody, your father, and you, were swearing in front of your daughter?
I did not swear in front of my daughter. When the swearing started, I sent her inside.
Okay.
I've never sworn at my daughter.
And then you said that after she started yelling at you during this conversation, that she said she was going to cause a miscarriage and make you lose the baby.
I said that, and my dad witnessed that. My dad heard that.
Wouldn't it be more accurate to say that you informed your father that you were going to call your husband and tell him that she had said that?
I told my father I was going to call the cops.
Okay. So
and after I would let my
Ms.
husband know
Ms. Dakey, let me interrupt. I think I can kind of see where this is headed. Your client has plans to move out, you said, how soon?
They hope to be out by May 1st, assuming they're able to close on their house tomorrow.
I'm wondering if I modified the PPO to allow her on the premises, but to prohibit confronting speaking with, having any contact whatsoever with Ms. Amber Benton, whether that would solve this. That seems to be the major concern from Ms. Amber Benton, is that she not have to deal with her mother-in-law trying to get into her part of the house or yelling at her or confronting her. If I were to modify the PPO to allow her back in, but to prohibit all confrontation, communication, etc., would that be a resolution that would allow Ms. Benton and her husband to move out? I throw that out as a possibility.
Sure. And Judge, I know I do have an audio of the argument on the 30th, which I think casts a very different light than the light Ms. Benton is providing. My client, I know does intend to move out, doesn't intend to have further contact with them. They would need to have access to the garage so that they can load up a trailer in the garage and move things out. So they would need some limited cooperation from Ms. Benton and her husband to get that stuff taken care of.
But the garage is a point of access to this lower living quarters, correct?
That is correct.
So she could come and go from the garage without having any interaction with the upper story whatsoever.
That is correct. And Officer Jacobson, who's familiar with the layout, I can see him nodding as well. That's correct, but they've locked that door. So during the winter, they had to go all the way around outside. So they would need to, the Bentons who own the property would need to leave the door down to my client's apartment unlocked and the
garage doors.
The garage door unlocked so they could get in and out to facilitate.
Do both parties use the garage?
Judge, may I speak?
They both had stored cars.
They
They both had stored cars in the garage during the winter. And at one point, Jody Benton was unable had to call the police to get access to her vehicle because they had locked them out of the garage. But yes, they both have utilized the garage.
So is there, and I can't picture the layout, but so there's access from the garage to the lower level and there's access from the garage to the upper level?
Yes.
Yes, sir.
So if they're both using the garage, there's an opportunity for confrontation and conflict.
Yes, sir.
Well, I would say we're talking about a fairly short period of time here. If Amber Benton just kept her door to the garage locked and stayed out of the garage while they were there shouldn't be an issue.
All right, let me, Amber, I know you want to say something. Go ahead.
We don't smoke in our house, and we smoke out in the garage. We do not smoke cigarettes in our house. And they also have the key to the garage. We all do.
All right. So, if we limited their access to the garage to certain time periods, could that be a workable resolution? I see that there's a horrendous amount of tension, turmoil, and conflict between you and your in-laws. I get that. What I'm trying to do, that's not good for anybody. If I could fashion a temporary order that just keeps you away from each other and prohibits them from confronting you, even speaking with you, period. And from access to the garage, except during very specific time periods, can we achieve this? Clearly, they're going to need to get in to get their stuff out. At some point, they need to do that. I don't want there to be any opportunity for conflict for either way, regardless of who's responsible for it. If I make it so that that can't happen, could this be an acceptable resolution?
May I say something?
Well, hold on. Let me hear from Amber.
I could probably do that as long as their dogs are not on my property and the cops are here while they're doing it. And I have a paper saying that they will be out March 30th or April 30th. And I do not want them having an extra day. They have to be out April 30th, like they signed on the paperwork we have. And I can bring that paperwork in here and show you. They said that they would be out by April 30th. I'll agree to those terms if they're out on the 30th and their dogs are not here. Their dogs have damaged my property. I have over 30 holes in my backyard from her dog digging.
All right, so Ms. Jody Benton, you wanted to say something?
Yes. Well, first of all, my husband had complete heart failure and a stroke 9 months ago. He has trouble walking up the hill to get into the car. He tires easy. He cannot help me do any of the lifting. He's not released from the doctors yet. He can't do any of that. I have to do it myself. As for my goal is May 1st. I just lost 2 weeks worth of packing that I have to do myself because of this. And I have never threatened her. As for the doors, the door that they come out opens to the right. The door that we go into the garage also opens that way. When they have their door open, when they're out there smoking, we don't know that they're out there smoking. We can't see their door. When we open our door to go in the garage, it hits their door. We've talked to Sean about this, and he says, yeah, we're going to have to keep the door shut because there's no way we can open our door without hitting their door if it's open. So there was no intentional trying to slam a door in there. I have never threatened her. I have never.
Well, hold on. I don't want to hear a defense to the PPO. I was simply trying to explore whether there's some measure that I could put in place until you're able to move out that keeps the contact from happening. That's what I was exploring.
Right. I understand that. I can do that. I just can't. I mean, it's going to be an all-day thing. I'll have to go in the morning, pack the boxes, load the trailer up, and it's going to take a good while to do that. So as for telling me I have 3 hours each day to do it, if I do that, there's no way I'm going to be out by May 30th or March 30th, April 30th. I'm sorry. There's no way if I only have a period of time. It's a lot of packing. I have nothing packed.
And realistically, the sheriff's department can't provide an officer to just sit there all day for multiple days to pack an apartment and move it out. That's just not realistic. But I don't think Jody has any issue with the PPO staying in effect as long as the provision that she can't be at the house even is just suspended until May 1st. Is that right, Jody?
That's right. My dogs, I have no place for my dogs. My dogs have to be there with me until we can get in the other house and get it set up with them. I have to keep my dogs with me.
I cannot allow her.
Hold on. Where are the dogs now?
They're with me. We've been at hotels and everything else. We have no place for our dogs. And they're in a fenced-in yard. No, I cannot put my dogs in a kennel. They are so stressed. No, they're stressed out. Where we are, they're at their house. If you walk out our door, there's a fenced-in yard. Their dogs cannot get to them. Their dogs cannot get to their dogs. They're in a totally fenced-in yard. The only way they can interact with my dogs is if they walk through a gate into the fence.
It sounds like her problem with the dogs is them digging up her backyard.
They're not. There's 3 little holes. I filled in the big hole their dog dug in the corner so I can mow. And my dog is around, there's 3 little holes around the fence and I've already filled them in. I had full intentions of taking and repairing their dog holes too in that yard before we left. I'm not going to leave them.
I have proof of all those holes that were dug.
There's not 30 holes back there.
My husband has pictures on his phone. He took pictures.
I'd
I
like to
also
see
have pictures that she fixed my garage doors. So
No.
Either way, I do not want the dogs there. I will agree to your terms, sir, but her dogs are not allowed at my property, not with how vicious they are.
My dogs are not vicious.
Judge, this is essentially an end run around the fact that she can't evict people during COVID. That's all this PPO has been. She wants them out now.
The PPO is
And she's
my
forced them to
child.
spend a lot of money on hotels and make other arrangements because she got an ex parte PPO.
This PPO is to protect me, my 4-year-old daughter, and my unborn child. That is what the PPO order is for. And I have my husband that can sit in here and justify everything that I have said. Because he has been there for the whole thing.
I personally have great trouble with issuing PPOs as eviction orders. I routinely deny them. I do see a need for a PPO so that there's no interaction, no confrontation, anything of that sort. I don't see a need for a PPO that absolutely evicts them out of the premises. My inclination is to amend the PPO to prohibit confrontation, interaction, communication of any kind, and that's as far as I'm willing to go with the PPO.
Thank you, Judge.
So I realize I haven't heard from all of the witnesses, but frankly, there isn't anything that's even been offered that's going to convince me that merely being present in premises that they were otherwise lawfully entitled to occupy is itself something that is properly within the scope of a PPO. I absolutely find that a PPO is necessary to prohibit confronting, approaching, communicating with Amber Benton. But that's as far as I'm willing to go with a PPO. And I would not hesitate to find someone in violation of this PPO if I find out there's been a confrontation in violation of the PPO. So Ms. Danke, if you could prepare that revised PPO, I will sign it and strongly caution Ms. Jody Benton to have zero contact with Amber Benton. If she approaches you, you turn around and walk away. If there's a confrontation, you're the one that's going to be in trouble, not her. But it is not going to prohibit presence in the lower portion of this property. I'm going to restore that because that's not the proper scope of a PPO, is to evict someone.
And just so
Ms.
that there's
Danke?
not a concern, that does include access to the garage as well?
Absolutely, that's part of the premises.
Okay, thank
But
you.
if Amber Benton is present in the garage, wait until she's gone. Do not confront her. Mr. Jacobson?
We're just gonna ask about the dogs.
The dogs were part of the rental agreement. I'm not gonna issue anything with respect to the dogs.
Okay, sir.
Thank you, Judge.
That's a limit.
Officer Jacobson, I appreciate your presence. You can go ahead and go. Sorry, it took all your morning.
I'm here until they tell me to go home. Have a good day.
All right, thank you. I'll watch for that order, Ms. Danke.
I'll submit that order. Thank you, Judge. Jody, I'll give you a call.
All right, thank you.
Thank you. That concludes our hearing.